Good morning, everybody. We're back again with this week's webisode of Fishwick and Associates. And this week, I believe, John, we are talking about our civil rights case and some of the civil rights cases in the Supreme Court. Is that correct?
That's right, Zach. It's important work that we do. We're very proud of it. You know, we were honored last week to talk to Senator Tim Kaine about his civil rights work. And this week, we thought we'd follow up and talk a little bit about the specific work that we're doing.
Okay, well, good. Well, I'll go ahead and kick it to Daniel. Daniel, I understand that there's something new with the Supreme Court involving LGBTQ. Is that correct?
There is. So on Monday, the Supreme Court came out with a decision in the case of Bostock v. Clayton County, Georgia. And there are actually three cases, but they were consolidated to because they all involve similar issues. The common question was whether Title VII of the Civil Rights Act prevents employment discrimination based on a person's sexual orientation or gender identity. So in the lead case, the Bostock case, the plaintiff was an employee of Clayton County, Georgia, and he was fired after he joined the gay softball league and kind of promoted it, and he claimed that he was fired on that basis. So he sued for employment discrimination under Title VII, which states that it is illegal to discriminate in any hiring or employment practice based on an individual's race, color, religion, sex, or national origin. And the focus there was the prohibition on discrimination based on sex. And so both the trial court and the initial appellate court, the 11th Circuit, they held that discrimination based on sexual orientation isn't covered by Title VII. Bostock says that, well, discrimination based on sexual orientation is, necessarily discrimination based on sex. And that's the argument that wins the day at the Supreme Court. And the kind of interesting thing about this decision is the breakdown of the justices who voted. So unsurprisingly, the court's liberal wing, they vote for this more expansive view of Title VII to where it prohibits discrimination based on sexual orientation or gender identity. But so do Justices Roberts and Gorsuch. And Gorsuch, the Trump appointee, he actually writes the opinion. And it was sort of typical for his judicial style is that the ruling relies pretty much on just the plain language of the text of the Civil Rights Act, Title VII. Everyone in this case, they pretty much agree that, in 1964, when the Civil Rights Act was passed, Congress was probably not thinking about the LGBTQ plus community. That wasn't really in their heads back in 1964. But that doesn't really matter, Gorsuch says, and the majority of the Supreme Court agrees. It's a 6-3 decision because the statute says sex, and if you discriminate based on sexual orientation, you must be discriminating based on sex because let's say you fire someone, an employer fires someone because they're male and they're attracted to males. And that means that if they were female, you wouldn't be firing them because they would be a female attracted to males, and that's heterosexuality. So what does the decision mean going forward? Mm-hmm. I guess, well, it will require employers, to think twice about, their hiring and firing practices in the future, which is a good thing. But it'll also open the door for a lot of, discriminated folks in this country to, seek justice for their unequal treatment, which prior to this ruling was, perfectly legal.
Okay. Well, that's interesting. And you said that's currently going on right now, correct?
That is, yes.
Okay. We'll have to come back on a future episode and follow up and see where it is, and you can give us a rundown and a debrief on that. Now, John, at Fishwick and Associates, we're pretty well known at, we have some civil rights work ourselves, and you want to go ahead and talk about some of the cases we've done or we have?
Yes, Zach, thank you. People talk about civil rights, and I think it's important to kind of understand what that means in the legal system. So the first area is in 1871, Congress passed laws to protect African Americans after the Civil War in the South for discrimination against them and for things that were done by local government officials, retaliation after the war. And so the cases that we've worked on are what people kind of commonly call, officer-involved shootings. Where we've represent people who have been, families where somebody has been killed in those, very tragic situations. And what those cases say, Zach, is if somebody under color of state law violates someone's civil rights, then they can bring a case in federal court. And those are the cases that we work on. And so that's an older law, but it's important law, so that if somebody uses excessive force and kills somebody, then you can bring a case. There's a big debate going on now in the country and a lot of these protests, and it's an important debate. Officers in local governments through the court system since that law was passed have been given a lot of protection under what's called, and this is in the weeds of the legal world, but it's what's called qualified immunity. qualified immunity says that the officer has to know about that constitutional right at the time they violated it. And so a number of courts have had different interpretations of that, but that has provided protection to government officials or law enforcement officials. And we face those challenges in courts. But I think it is an interesting time doing this legal work. We've got a lot of experience doing it. I think you're seeing transitions in the law. There was a recent case from the federal court system that we're under called the Fourth Circuit that I think is expanding that, giving a broader view of that. But it's important work. You know, it's something that I believe to my core, and that is, if the least of us doesn't have a right, then none of us has a right. You know, if somebody who's, you know, killed at the hands of the police or in a prison, if they don't have any kind of constitutional rights, then you and I don't have constitutional rights. And so I think it's very important that we pursue these cases. We're very careful about how we vet them, and we really look into them before we agree to take a case like this, because they're challenging cases, but it's critically important work, and we're very proud of it. The other kind of civil rights case that we have is what Daniel touched on, Judge Daniel touched on this morning, and that is employment cases under Title VII. You know, Lyndon Johnson and the Great Society and Congress in 1965 passed a number of laws protecting African Americans and other women and folks of certain, and then later it was expanded to age discrimination for discrimination in the workplace. You can't discriminate against somebody because of their race. You can't discriminate because of their gender. You can't discriminate against because of their religious beliefs. And now you can't discriminate because of their sexual orientation. And so these are important cases. Again, we spend a lot of time vetting those cases, but we think it's important that, you know, if you're not in your workplace, you never should be discriminated against for any of those constitutionally protected reasons. And that's a civil rights case in the employment case. So again, these are important rights. It's, you know, as a free, open society, if people are being discriminated where they're earning their living to support their families, then, you know, that's a really bad situation. And so we want to stand up for those people. And we currently have cases where we're representing folks for race discrimination, gender discrimination, and as well as age discrimination. And also part of that is disability discrimination. You can't discriminate against somebody because they have a disability. So, you know, Congress has passed these laws, the courts interpret them. And so each case kind of stands on its own. And so we spend a lot of time with you, obviously, Zach, as our investigator, investigating these cases for everything that's happened in them before we bring these cases. But we think they're critical cases. I think it's what we're known from. A lot of lawyers shy away from them. A lot of lawyers refer these cases to us. But we think it's important. You know, I think you have to stand up for people in these challenging circumstances. And people don't know, oftentimes when somebody gets blindsided by something happening bad in their life, it's not a great time for them they weren't thinking about standing up and fighting. They got a lot of things going on in their lives, but it's important that they do stand up at those times. And when we agree to take those cases, we help them stand up for the rights. So we're proud of that work, and we've made a real commitment to it. In fact, Daniel, being a younger lawyer, the federal court system has what they call a system where the court will call us, or one of the law clerks will call us about representing prisoners on a pro bono basis in the federal court system. And they have the kind of cases that I talked about earlier, 1983 cases. We've agreed to take on 3 of those cases. And I know, Daniel, you've been working on several of those. Why don't you tell our viewers just a little bit about that pro bono system within the federal court system that we want to support and think is important, again, to make sure. A lot of people say, well, why should prisoners have rights? Well, prisoners don't have rights. You and I don't have rights. And what sort of cases are these, Daniel?
You're still
right. So basically what happens is a lot of times prisoners, they'll file what's called a pro se lawsuit. You know, they'll file a lawsuit without a lawyer, you know, arguing that, you know, their constitutional rights have been violated while they're in prison. And what happens in a lot of these cases is that, you know, the court will examine their complaint, and the court will say, you know, either all these claims must be dismissed or some of these claims must be dismissed, and sometimes it'll get appealed to the Fourth Circuit Court of Appeals, and then the Fourth Circuit Court of Appeals will say that, you know, some of these claims can survive this, you know, kind of early dismissal. And once that happens, you know, once the claims are really narrowed down to what has some real meat to it, at that point the prisoner thinks, well, you know, I really need legal representation here. But unlike a criminal case, you don't have a constitutional right to a lawyer. and being in prison, it's difficult to afford a lawyer. So what the court does, the court will reach out to attorneys who have expressed an interest in representing these prisoner clients pro bono. That is, they don't have to pay anything, and the court will actually reimburse certain costs of the representation, which makes it easier for attorneys to represent these folks pro bono. And so the court's really kind of acting like a middleman here, connecting prisoners who need legal representation with lawyers who are willing to do that, pro bono. And these, these kind of cases run the gamut from, First Amendment violations to the Fourth Amendment violations to, cruel and unusual punishment with the Eighth Amendment. And so there are all sorts of constitutional issues that arise in these cases.
Yeah, so we think it's important work to do. We're committed to ensuring that folks' rights are enforced, and we think it's important to support programs like this within our court system. We regularly do that, and we'll continue to do that. It's a big part of our practice, and so we appreciate. I keep dropping this thing today, Zach. We have too much going on here.
We'll fix it in post.
No, that's all right. But anyways, I really appreciate the opportunity to talk about civil rights, the work we're doing. Daniel, I really appreciate that update. Excellent job with that. And it's good to see everybody again today.
Well, and before we sign off, John, there's one thing I'd just like to add. Our moral compass at Fishwick and Associates, you could say it's set to noble, but when you boil it down to it, it's the right thing to do. And it's good work that we do. And like you said, we vet everything, we investigate everything, and we don't take it lightly. I mean, we've put in 12 plus months before we even took on a case, and that case is steering in the right direction. So, I mean, it's feel good work on top of, like you said, when it boils down to everything, we're all human and we all need an advocate. So,
yep.
And to our viewers out there, I'd just like to say, if you have a question about any of this, feel free to contact us. Go to our website, look on our website. Daniel keeps a regular blog where he also links these videos. And also, please comment below. If you'd like to see something or a specific topic, just let us know, and we'd be glad to discuss it with you or on the video webisode. So again, thank you very much. Like, comment, and subscribe, and we will see you guys next week.
Thank you.
Thank you.